Hello, my name is Tom Fletcher. I'm the Chief of Police for the Blue Earth Police Department. Today we're going to be holding a virtual community notification and education meeting about a level 3 sex offender who is reintegrating in our community. Under normal circumstances, we would host this as a community meeting with the public. But unfortunately, due to the constraints of the COVID-19 pandemic and the short notice we received on his release, this format was the fastest and safest way for us to broadly disseminate this very important information. The purpose of this meeting is to inform you about the sex offender program, to give you information about the community notification process, and to give you specific information about a sex offender who has moved into our community named Larry Hinton in the 200 block of West 1st Street. This meeting is also to enhance our community members' individual and collective safety. I realize that as you watch this meeting, you may have questions. I hope that during this presentation, we'll be able to answer those questions. I thank you for taking the time to watch. With that, I'm going to hand it over to Brad Vanderbeck of the Minnesota Department of Corrections.
Well, hello and thank you. As the chief said, my name is Brad Vandervet, and I am with the Minnesota Department of Corrections in the Risk Assessment and Community Notification Unit. And my presentation today is going to come in really 3 distinct parts. I'm going to speak to you on more broad terms about the state's overall risk management system and how it applies to individuals like Mr. Hinton. And I'm going to use that information then as an overlay as we get into the specific details about him. And then I will conclude with information and resources for you to assist as you are implementing this into your existing family and community safety planning efforts. So without further ado, where I really like to start conversations like this is with what we as a community all kind of have a baseline understanding of. And that is that individuals who engage in this kind of harm, sexual harm, exist. And what we know from our data collection and research is that it is entirely likely that there is a registered individual within every community across Minnesota and beyond. And so broad awareness is really the key goal of any notification meeting like this. Now, as I go forward, I want to put in your mind an analogy of a funnel as we're talking about all of the broader contexts that go into this. And know that at the very largest end of that funnel is those incidences that occur. And what we know is that of those that occur, only a percentage go on to be reported to law enforcement. And of those reported, only a portion of that group go on to receive formal charges. And of those charged, only a portion of that group will go on to receive sentences. And as we get into this further, you'll see that of those sentenced, even a smaller portion yet will go on to cross the threshold of prison. And so as we go forward, I want you to have that analogy of that larger funneling effect that's going on. So one of the first components of the state's risk management system that I'd like to discuss with you today is the registry. Now, the registry came online in 1991 as really born out of advocacy and efforts of the Jacob Wetterling family following the abduction of Jacob and on into other advocacy groups that really went around to law enforcement agencies throughout the state and nation and asked them, how can we best serve and assist you in this important work? And law enforcement said resoundingly, what we need is a system that collates our data so that it's easily accessed when it's most critical. Because prior to the registry, what was happening was each law enforcement agency that may have encountered a registrant or somebody engaging in sexual misconduct would house that information in their data systems and would share it only after the individual became known to another neighboring community. And so with the registry, this information is broadly available to all law enforcement agencies throughout the state so that they can readily access data when it's most critical. So the registry is maintained and governed by the Bureau of Criminal Apprehension. And so the BCA collects and retains a number of components on individual registrants. things like their address. That includes their primary address and secondary addresses, places they may frequent. Think places like family members' homes that they may visit with some regularity, significant others' houses, perhaps vacation properties, and so on. It also maintains their employment information. And if a registrant is operating a motor vehicle as a part of their employment obligations, that information must also be made known to law enforcement. Other components that are on the registry are their school or vocational educational stuff, if they're set up and enrolled to attend. Vehicles, any other vehicles that they themselves either use, own, or possess. So even the old broken down car in the backyard must be known to law enforcement. Additional components of the registry include things like their phone numbers and any place that they may rent. Think things like storage lockers and so on. And so that is the robustness of the registry. Now the registry by law is deemed private information, and therefore it is for law enforcement purposes only. And law enforcement can share that information among each other and corrections agencies. So now the next question that comes up in meetings like this is then who has to register on this program? And initially when it came online in the early 90s, it was specific to those convicted or charged with criminal sexual conduct or any kind of sexual conduct involving minors, to include things like child pornography. But the state of Minnesota saw the benefit of the registry and its ability to assist law enforcement in its policing efforts, and actually grew it to include other crimes that are non-sex related, such as kidnapping and false imprisonment. And this is why some of you may remember the name change from the sex offender registry to the predatory offender registry. And an easy way to keep it straight in your mind as we go forward today into this information is this: that all sex offenders are predatory offenders, while not all predatory offenders are sex offenders. And so just as we go forward, use that as a way to keep it straight. Now, one of the things I'm able to share in meetings like this is kind of a broad 30,000-foot flyover of the registry, a snapshot in time, to really assist you in driving home that funnel analogy. And as you can see here from my information, as of the first of the year, there were 18,798 registered individuals in Minnesota. And that would be all of them. That would be those incarcerated. That would be those that are no level assigned because they didn't go to prison or were juveniles. That would be those levels 1, 2, or 3. And as of the 21st, when I last ran these numbers, you can see in your communities, Faribault County, there were 64 registered individuals. Again, that's all of the levels and those with no level assigned, of which 6 are those subject to broad public notification. You can look at Blue Earth proper and see that there are 11 registrants within that area or this neighborhood, and 3 of whom are those subject to public notification, that broad notification. And as you look at communities around the area, you'll see the number to the left is all of the registrants, again, no level all the way up and through level 3, and the number to the right is those that are subject to broad public notification. You can see just from this snapshot that there are registrants in and around all communities, and we know that they are crossing all manner of county lines, city boundaries, municipal boundaries, and so on for all types of purposes, for work purposes, for family, recreation, or for meeting their basic life needs, going shopping, and so on. And so broad awareness is just so critical as we go forward. The next thing I want to share with you today regarding the state's risk management system as a whole is the Community Notification Act. Now, the Community Notification Act came online in 1997 and is born out of the knowledge from our research studies that a well-informed community is in fact a safer community. And we in the Department of Corrections thank the police department in all of its efforts to ensure that this information gets out to the broadest amount of people possible. And because the Community Notification Act is the reason we're here today and able to share this information, it makes sense to go into more detail as to how it functions. So in order to be subject to notification, a registrant must cross the threshold of prison. That can be any prison in the state of Minnesota or any prison within the United States to include U.S. territories. That can include federal prisons and military prisons, and it also includes those who have been civilly committed for sex offending behavior. So those that it does not include, those who get no level assigned, are those who were charged and convicted as juveniles, and those who have been granted a stayed or probationary sentence by the court and allowed to remain in the community, therefore not crossing the threshold of prison. So when you're looking at the Notification Act, the next question that typically comes up is, okay, well then who does what with those that are subject to notification? And the Department of Corrections is tasked with the responsibility to assess and assign risk levels. And that is done through the End of Confinement Review Committee, or the ECRC. 90 days prior to a registrant's initial release into the community or earlier, the ECRC will convene and they will go over all the documentation and data available on that registrant. And in that information will be the score from a risk assessment tool that was created here in Minnesota, known as the MinSOST, the Minnesota Sex Offender Screening Tool. Now this tool came about after an exhaustive study conducted by the Department of Corrections that began in the early 2000s and began in the early 90s and ran initially all the way through the early 2000s with a follow-up companion study completed in 2012. That initial study followed over 3,166 sex offenders into the community at their release throughout that period of time, and it marked their successes and their failures. And the information attained from that data set is what has been then subjected to that scientific review process and has now become those known predictive risk factors that are applied in this risk assessment tool. So when I use the terms of levels 1, 2, and 3 today, know that I'm speaking specifically to that study. So when I say a registrant is a level 1 individual, I'm saying they have, or at that time of that assessment, a lower amount of those known predictive risk factors as compared to that peer group, that data set. Level 2 has a moderate amount of those known predictive risk factors, and a level 3 has a higher amount of those known predictive risk factors. Things to keep in mind with risk assessment studies that are important as you go forward today is to know that no risk assessment tool is capable of predicting the future. And also know that risk is dynamic. Those factors that are at play are fluctuating and changing. And we are constantly working with our law enforcement partners and through our corrections teams to implement those mitigating factors, those things that are going to mitigate risk and reduce it. A risk level 1 individual today, if they are not abiding by all of the skills and tools that they've received through their time on supervision, may find that their risk is going to go up. So a level 1 could find themselves moving up the line if the need arises. The same can be said for a level 3 today, who if through time and showing that they've been doing well in the community for a very long period of time, they can potentially find that their risk level will be reduced. And so keep that in mind as we go forward. Now, once a level has been assessed and assigned, the handoff then goes to law enforcement. And law enforcement will provide notification within the scope of the risk level assigned. So with a risk level 1 individual, law enforcement will notify other law enforcement agencies or correctional agencies. They will notify victims of or witnesses to the offense if they've requested that level of enhanced notification. And they will notify immediate adult household members residing with that registrant in that home. And that is the scope of a level 1 notification. Now with a level 2 notification, law enforcement will add to that group of individuals and entities we just discussed, and they may designate other individuals or entities that they determine to be at specific risk based on the individual registrant's known pattern of conduct. It's often believed with a level 2 that this means schools and daycares and churches will get notified. Now, while that may very well be true, that is not always the case. So for example, if you have a level 2 registrant and law enforcement receives that packet of information from the Risk Assessment Community Notification Unit, and they determine in their review that this individual focuses their conduct and behavior on adult females at social gatherings, think places like bars or concert venues, then law enforcement in that scenario may very well decide it makes no sense, it does nothing to enhance public safety further, to notify the local daycare that serves children from birth to school age. As opposed, they would then turn their notification efforts in that case over to the proprietors of those bars or venues so that they can share it amongst their security staff and so on, and implement whatever safety planning they have in place. On the flip side of that, with a level 2 notification, if law enforcement gets information that a registrant, level 2, coming into their community, and they determine that this person focuses their conduct and behavior on those unaccompanied minors, teens, in transit from school to after-school programs or home. And law enforcement knows in the community there's a teen hotspot where they like to hang out. In that scenario, they will go to the proprietor of that organization and let them know of this individual. Say something to the effect of, if you see this man loitering or hanging out or establishing relationships with the children in this area, give us a call and let us know. We're going to come out and find out more about what he may be up to. And so that is the nuance of a level 2 notification. And then with level 3 notification, those with that higher amount of those predictive or known predictive risk factors, law enforcement engages in broad public notification. And that can come in many different shapes and sizes. It really is dependent on how local law enforcement communicates best with its community. And again, we thank the Blue Earth Police Department and all of its efforts to get this out to you today. So with that narrowing funnel analogy in your mind, I want to show you the narrowest point we know about. And that is those who cross the threshold of prison. So year after year, those individuals coming into the prison system that are on the registry does fluctuate and change. But what remains fairly static every year is the breakdown of risk levels assigned. As you can see here from this information, it is the smallest amount that get assigned level 3, 15% on average. And so those are the groups of people we get to talk about more broadly. But know that the same components and factors we do get to discuss with these unique individuals can be applied more broadly to anyone in and around areas. So use it as you're implementing those safety planning efforts. As of the 21st, just to kind of give you a final snapshot, there were 452 registrants within Minnesota actively residing in its communities, 7 of whom are out of compliance with the registry, meaning their address is not known and they need to be brought back into compliance. And so that broad awareness, again, is just so critical because we know that these individuals exist further beyond where their head hits the pillow at night. They're traveling for all manner of reasons. Other information I want to share with you today from that research study and others to apply in those safety planning efforts. I actually pulled this one from the U.S. Department of Justice because it correlates very nicely with what the state study shows, and they really do align. And that is the relationship between children and the people that harm them. And what we know from our data is that the vast majority of those who hurt children are known to them. Either they are immediate or extended family members or someone whom they are acquainted to. And they use that relationship to gain and exploit trust. Now from this data, you'll see that the smaller percentage, that 7%, falls into the stranger category. Now, obviously, this is the category that gives us the most pause, as it should. Because when it comes to family members, we know who our family are. and we can set good, healthy boundaries with them. We also get to pick and choose as parents and loved ones who gets to have a relationship with our children. But that stranger group is beyond our direct influence or control, and so it's the one that captures our attention most. So it is worth breaking down to further detail what's going on there. So with this research study, the assessors had to create a cutoff point as to what constitutes a knowing or a relationship. And that line was determined to be 24 hours. If the researchers could not determine that a knowing between the offender and the victim existed of 24 hours or greater, they fell into the stranger category. So inevitably what that meant is scenarios like this, where two teens meet up at a house party who had not previously known each other but maybe attended the same school, had hit it off, and the night was going the way it was going, and they left the group of their own free will and went somewhere secluded, and the night took an awful turn. That scenario would fall into the stranger category. But what we as parents and as family members and community members tend to think of more when we think of stranger is that person just outside of our awareness, just beyond our attention and knowledge. And that group actually falls into about a 3% category. Now that is cold comfort, I'm well aware. But what I want you to do is you're applying your resources, both family level and community level. I want you focusing on all of this information, not just the 3%. I want your attention and awareness spread out as best possible, because the greater likelihood is that it's someone exploiting a relationship that they've built. Other data I want to share with you as you're contemplating those safety planning efforts is the age breakdowns of those harmed. Now, as you look at this data, you'll see it's broken into thirds, but then you'll start to look at the ages on the side, and you'll see that 2/3 of this group are children. And then you'll look even further and you'll see the narrowest age range, that 13 to 17 age range, constitutes 33% of those impacted and harmed. That's 9% of the population, and that is a staggering number. So it's worth unpacking what's going on here. Well, we know in the 0 to 12 age range that it's very much the parents and trusted loved ones that are directly influencing those children. And so we want to provide those people with the best resources possible in those critical years so that they can vet the people coming into their children's lives. But inevitably what happens when we hit those critical teenage years is the very thing we work so hard to achieve in a community. And that is a place where our kids can go out and express their own autonomy in their community, where they can socialize and congregate on their own. And inevitably what that means is that our children are forming relationships outside of the watchful eyes of that trusted adult support network. And so what we've learned through our work and efforts with victim advocacy groups throughout the state is that we're getting away from that older model of the talk, where we pull our teen aside at that critical age and we pull back the veil just enough to show them that the world is not as safe as it had been made to be for them when they were younger. Now, often this would be met with one of two reactions, either one, fear from the teen, or two, rejection, where they say, no, mom and dad, you don't understand, it's perfectly safe out there. And what we found is actually what works better is a lot of little talks, age appropriate in their design, starting from those young ages, working their way all the way up and through into those adult years that grow with the child and build upon the knowledge from the first initial talk. That work to ensure that we're not frightening our children, because we know that scared kids do not equal safer kids. But as parents and loved ones, we also know that we need our children to understand that nice people don't always equal safe people. And so I will provide you with some additional resources as you're thinking about how to have those conversations or add or augment those safety plans to include those conversations. Now I'd like you to use the information I provided you this far as an overlay as we get into the specific details about the man you're here to learn about today. This is Larry Hinton. First, let me speak about photographs. Photographs are going to be updated on average every 12 months annually, or should the subject significantly change or modify their appearance. If you were to see Mr. Hinton in the community and you were to see that he had changed his appearance in some way where he no longer looked like these photos, I want you to certainly contact either his supervision team or law enforcement, and they will work together to attain updated photos and make sure they get put into the registry where I will attain them and get them on the web, so that for as long as this man is subject to broad public notification, you will always have an accurate photographic depiction of him. These are Mr. Hinton's vitals. He's currently 54 years of age, and he is residing, as the chief said, in the 200 block of West 1st Street here in Blue Earth. Now, often in meetings like this, a question that comes up is, Brad, can you tell us where he lives? We would find it very comforting to know where his head hits the pillow at night. And as you'll recall from my earlier information, the data collected by the registry is private in nature. However, we do accomplish a lot with proximal addresses. Undoubtedly, those who live in this area either are already aware of Mr. Hinton or will soon become aware of him as they see him as he comes and goes. And they will share that information in and among themselves, and that is just fine. But what we do not want is for his specific information to become broadly publicly available so that somebody from well outside of your community who has no stake in what goes on here comes in to enact some vigilante revenge scenario that does nothing to mitigate risk and only serves to disrupt all the hard work you've put into your neighborhoods and community. This is Mr. Hinton's registrable offense history. This is exactly from the fact sheet that you've been provided, and it focuses solely on those convictions that placed him into the registry and ultimately were weighted in his risk level assessment. This is not an exhaustive criminal history. If you're interested in Mr. Hinton's full criminal history, you can go on to the BCA's website and go to the public criminal history search function, enter in his first name, last name, and date of birth, and you can see there all of his convictions if you're interested. But for today's purposes, because the Notification Act focuses on those registrable offenses, we're going to stay focused on those as well. So in 1994, Mr. Hinton was convicted of criminal sexual conduct in the first degree in Martin County for a 1993 offense. This offense was against an adult female whom he was very well acquainted to. They were in a relationship together that had ended. And after the relationship had ended, he broke into her home once she returned, and there he used violence and threats to gain and maintain control. And for that crime, he received an 86-month commit. Now I'm going to take a moment and explain the next question that often comes up in meetings like this. It's, Brad, why do people who engage in this kind of harm that shocks the conscience, why do they get to come out? And the reason in part lies here with determinate sentencing. Prior to determinate sentencing, Minnesota had a system of parole. And with that system, the individual would have to go before a parole board and they would determine whether or not this individual is going to be re-entered into the community with time hanging over their head. Now, for those who engaged in this type of harm that just shocks the public conscience, you can well imagine they found it very difficult to be granted parole out into the community. Now, that would lead to them staying in through expiration of their sentence, where at the end they'd be walked to the door and told, don't come back. Now, oftentimes upon hearing that, the community sentiment is, you know what, Brad, that's just fine. He can serve his old time. We're okay with that. But what we found was through all that data and research was that that model did not impact recidivism rates as well as we wanted it to. So with determinate sentencing, we found a model that actually did significantly change recidivism rates going forward. And the way it works is the crime is punished by a set presumptive disposition set by the Sentencing Guidelines Commission in Minnesota. So the commission determines a severity level for every crime in the books, and then that's taken and weighted against the registrant or the individual going before the court against their full criminal history. And the two combined together will give a presumptive disposition. And the court can operate within that disposition box. And so with this 86 months being the disposition, it's broken into thirds. 2/3 by law will be served in the institution if the individual crosses that threshold, if the court revokes their stay or vacates their stay or directly orders them into prison. So 2/3 are served in the institution, and then by law, that final third is served in the community under community supervision with both law enforcement and corrections working together to manage the individual. And this is a means by which to apply all of the tools and skills that they've gained while in the institution through therapy and counseling and treatment, and then transition that into the community through safety planning efforts, where the agents can monitor and watch how they're adjusting. And if they need to go back because of non-compliance or because they're struggling with certain components of those known patterns of risk, they can come back into the institution and receive further correctional time to adjust whatever may need to be changed. And then ultimately on to expiration, with that being the way to internalize for these individuals all of those skills and tools, so that when the agents are no longer connected to the file and that expiration has come, that they go forward to lead quiet lives, self-governing, and that is the goal. Now with Mr. Hinton, this was not his only registrable offense. So he came out of prison onto supervised release, and while he was out in the community, in 2000, he engaged in some additional criminal conduct. 2001, he was convicted of criminal sexual conduct in the first degree out of Martin County. This offense was against a teenage female, 13-year-old female, whom he was acquainted. He used that knowing and invited her into his vehicle with the promise of controlled substances. And she got into the vehicle of her own free will, where he then drove her off to a remote area and assaulted her. He used violence and coercion to gain that control. And for that crime, he received a 360-month commit to the Commissioner of Corrections. Now again, we just talked about determinate sentencing, but I do want to speak to that duration. That was considered an upward departure by the court, so it does reflect that responsivity of the court system in that broader risk management system the state utilizes. And you'll see upon that 2/3, when he hits that release point at 2/3, he has an additional 10-year conditional release period tacked on. And that ensures that that final third is extended for 10 years so that he has the benefit of that additional time working alongside his corrections team. And then while this was going on, Mr. Hinton had another offense in 2000. And so they occurred very close together. And so actually this offense was found out first, but through the investigation of this offense, the one against the 13-year-old became known. And so in 2001, he was convicted of criminal sexual conduct in the first degree, this time in Faribault County. This time he had asked for a ride from an acquaintance, an adult female, 30-year-old female, and she agreed to give him a ride. Once they were in the car, he began to assault her. And so he used his relationship to her, her comfort with him, knowing him, to get her to give him a ride. And then once in the vehicle where he had her isolated, he used force and a weapon to gain control. That he used a knife in this situation and threatened this victim's life. And for this crime, he received another 360-month commit, again, another upward departure with a 10-year conditional release period. So these were ran concurrently with one another. So Mr. Hinton's prison chronology breaks down like this. In 1994, he comes into prison for that CSC1, that criminal sexual conduct first degree, and was assessed and assigned and then released at that 2/3 mark as a risk level 1 individual. Remembering back that this is an individual that law enforcement is constrained by notification and can only notify other law enforcement agencies, victims of or witnesses to, and immediate adult household members. And in 2000, when those new sex offenses were found out by law enforcement and going through the court process, he went into custody and remained in custody all the way through sentencing on those new files, where he then re-entered prison. So he went from the county jails back into the prison facility on the new convictions for those 2 separate criminal sexual conduct first degree files in 2001. And he was released on his final third, by law mandated, has to come out into the community in May of this year, and has moved now into the Blue Earth community under intensive supervised release, which is another initiative of that broader risk management system. So as it sits today with Mr. Hinton, he will remain under correctional supervision with the Department of Corrections on intensive supervised release until May of 2040. And he will remain subject to the registry to that same date, May 23rd specifically of 2040. Because that is the longer running. It's 10 years or the duration of supervision, whichever is longer. So they will both expire. Should he comply, should he manage himself appropriately in the community, he will expire from the registry and come off of notification on May 23rd of 2040. Now at this time, I'd like to invite my colleagues from ISR to come up and provide you with some specific information on Mr. Hinton and how his supervision will look here in the community.
Hello, my name is Gary Wilford, and I work for the Minnesota Department of Corrections Intensive Supervised Release Team. As part of ISR goes, we have 3 main goals. The first goal being public safety. That is first and foremost what we want to accomplish here. And if it ever is in jeopardy, we will take measures to either use community resources to accomplish this or tighten supervision. The second part is compliance with release conditions. Mr. Hinton will have a wide range of conditions that he will be held accountable for, and these conditions relate to his previous behaviors and previous criminal history, and we've already seen what that looks like. Our third objective is for successful reintegration to the community. We want Mr. Hinton to have positive reinforcement and positive experiences within this community. Part of ISR's process in that is that we will promote him to be employed as well as participate in sex offender programming. There is a release process that goes with Mr. Hinton coming to this area. There is a joint and collaborative effort by both institution staff, whether that be a caseworker or case manager, as well as an agent, that being myself. Options that we look for is that we want Mr. Hinton to be supported physically, mentally, and financially in a residence that he can succeed at. We want Mr. Hinton to be in a supportive environment so that we can minimize any sort of risk factors and protect and maximize any protective factors or issues that might occur. Mr. Hinton will be placed on an ankle GPS monitor, and this GPS monitor will allow us to track both our locations and allow us to be sure he is accountable for his whereabouts. Mr. Hinton, when he's released from the facility, he is transported by an ISR agent to his approved residence. We do this, again, to ensure public safety and his accountability to make sure that he makes it home. The ISR program, we operate off a 24-hour, 7 days a week, 365-day program. There is always an agent that is working, whether it be days, nights, weekends, holidays. We have a highly structured environment. Mr. Hinton will be required to call in via a voicemail system every day that he is on supervision. So from the day he got out until the day he expires, we will always have contact with Mr. Hinton. We have weekly schedules that we must pre-approve. So Mr. Hinton must submit to us a schedule a week in advance that we must look at and pre-approve based off of what his supervision is. Mr. Hinton will also have parameters in place in regards to when he is allowed to come and go from his residence, as well as a restrictive curfew. ISR, we have a reduced caseload size. On average, each agent has around 12 to 15 clients per agent. This allows us to get to know these individuals on a very personal level. We have frequent face-to-face contact. At any week, we may see Mr. Hinton anywhere from 2 to 4 times. And we will also use our local law enforcement to either assist us with this or meet him outside of us seeing him. All visits are random and unannounced. There's never a time when Mr. Hinton will know that we are coming to see him, or what place, or where. And again, daily contact. Mr. Hinton must be in contact with agents every day he is on supervision, and we will always know his location and where he's supposed to be. The ISR team consists of 5 total agents, that being David Barledge, Kirsten Isaacson, McKay Carl, Eric Starkey, and myself. Our supervisor is Kelly Blake. We cover a wide range of areas and counties. We cover 11 counties, with Faribault County being one of them. The number on the bottom here is a voicemail number, 507-344-5288. Please do not hesitate to ever call that number, leave us a message with questions, issues, or concerns, and an agent will respond to you. If, however, the concerns are more severe or possibly an emergency, please contact your local law enforcement. We will work closely with them on supervising Mr. Hinton. Thank you.
Well, thank you, Gary. And as Gary said, it's really important to know who your best resources are. If you see Mr. Hinton, or as your awareness has been broadened, if you see anyone engaging in conduct or behavior that you believe is threatening or imminently dangerous, call 911. Make sure that information is getting to law enforcement. As you've seen, there could be a number of registrants in and around any area that we aren't able to share their information about. And so if you see something and you report it to law enforcement, you're assisting them in their efforts of managing this population. If you have questions about policing or just kind of procedural questions, you can certainly contact their non-emergency number as well. Other resources I want to share with you today is the Jacob Wetterling Resource Center, the JWRC. Let them be one of the foundational components as you are looking to add more of this into those safety planning efforts. As I spoke earlier about age-appropriate conversations with children so as not to incite fear, but also to help them understand how to talk to strangers, how to set body safety rules, and how to learn that nice people don't equal safe people. This is one of those great resources, and they are the subject matter experts. They will assist you in augmenting and implementing safety planning. They'll also come out to your community, speak to church groups, neighborhood groups, schools. They have workshops they'll put on for both children, adults, and so on. So definitely utilize them as a resource. Other resources I want to make sure I share with you today is your local victim services provider. The reality of the topic we're discussing today, and the statistics being what they are, is that somebody viewing this has either themselves been directly impacted by this type of harm or has supported somebody who has been impacted. And I want to make sure that you have readily available to you a resource to reach out to if this has triggered you. Because information like this, especially in this time with COVID and all of the other stresses on communities around the state, I want to make sure that you have their number readily available. Because with additional information like this, it can often lead people to feel like they're just overwhelmed. So to summarize all of the information I've thrown at you today, and thank you for bearing with me, if you take nothing else away from the information we've put out there, please let it be this. That from what we've seen and what we've learned through our research, and we know a lot, is that 90% of those individuals that have come through that full array of that state risk management system, who've become known as sex offenders, do not go on to reoffend in a same or similar fashion. 90% of those engaging in this type of harm are using their relationships to the victims to exploit that. Which means that even if today we could remove or eliminate all 18,700 some registrants from the state, put them on the moon, we would have only impacted sexual harm year after year by 10% or less. 90% of those engaging in this kind of harm are not known to the system as sex offenders. So that broad awareness is just so critical. It really does come down to that relationship component. That social proximity is so much more telling than any geographical proximity ever could be. Where a registrant's head hits the pillow at night is where they are at their lowest risk. Where they spend their waking hours is where we have to have our highest level of awareness. So even if a community were to say leveled offenders like this person cannot live here, and push them out to the fringes of their area, homeless, all they would have done is impact his risk factors and destabilized him. Because you can see that even though he may not live here, he will come back to here because this is where his resources are. So keep that in mind as you go forward and contemplate how to apply this information in those safety planning efforts. Some additional resources I just want you to have available. Please don't let this be the only information you receive on this important topic. As you go forward and you find other resources and information and you're looking at them and wondering if these are reputable or good resources, you can certainly contact any one of these agencies that I've already provided you to check and make sure. But just make sure you're vetting the information you're getting to ensure that it is good information. Lastly, as far as state resources go, I spoke briefly about the Bureau of Criminal Apprehension. While they maintain the Predatory Offender Registry, which is for law enforcement purposes only, you can go on to the BCA's website and do a public criminal history search. All you need is the individual's first name, last name, and date of birth. And if you're contemplating allowing somebody to establish a relationship with those you care most for, whether they're going to be a coach or they're going to be a tutor or whatever the case may be, I'd encourage you to utilize this tool because anyone on your list of consideration, if they're unwilling to provide their first name, last name, and date of birth, I would argue shouldn't be allowed on that list of consideration at all. And then lastly, the Minnesota Department of Corrections website. We house all of the data and research that I've been talking about today in its pure form. So if you're like me and naturally skeptical of some guy sitting on a camera spouting off details and a pie chart to you, do go on to that website and you can find all this research and data and review it yourself. Read it and draw your own conclusions. If you can't find this information, certainly contact me. I will be happy to get you over to it so that you can have access to it. We also maintain the offender locator. That is for anybody that is under the jurisdiction of the Department of Corrections, regardless of the offense. And so if you're thinking about those individuals that you've become aware of either through media reports or maybe you've been directly impacted by one and you're wondering what's going on with that individual, this is your search tool. And then lastly, that public registrant search function. Those 450 some I threw up on the screen earlier, of those individuals subject to broad public notification in and around Minnesota communities, they all exist there on that public registrant search. Now this is often confused as being the registry, which you see now it is not. The registry being for law enforcement purposes only. If you are interested in Mr. Hinton or anyone else, if they leave the community, this is often a really good tool to be notified. While law enforcement can provide notification to the community if a registrant leaves, they also have to weigh it against whether or not that person would return for any reason before they go and make a broad public notification that he is left, sounding an all clear, thereby dulling or diminishing awareness. And so, as you might well imagine, law enforcement is very cautious before doing that. But if they do move out, you would be able to see that on this public registrant search function. Now, typically with a meeting like this, we would open it up to a Q&A with you, the community. Now, obviously, as the chief indicated, given the restrictions of COVID, we're going to do a modified Q&A to assist you further.
So I'm gonna ask you guys a few questions that normally the general public would ask. Okay, so why does Larry Hinton have to live here?
Yeah, I mean, and so that's definitely a common question that comes up. And when it comes to who decides or how is it determined where they're going to reside? And so, much like Gary explained earlier, the individual registrant will submit a plan of where they want to go, where they have the most resources, those protective risk factors, those things that are going to move risk down. Things like access to employment, access to treatment, access to transportation, access to resources such as shelter and things like that. And so they will provide the plan, and then the agent will take a look, and remembering that the worst case scenario, the worst plan is homelessness, because that destabilizes this individual to where it becomes enormously difficult to track him. He can no longer plug in a GPS monitor if he's homeless. He has a hard time getting around and will likely fall out of communication with law enforcement and potentially his agent. And so having an actual house is so much better just in and of itself. Often, though, questions will come up with that of, well, this particular home is very near a place where children are known to congregate, be it a park, playground, school, daycare, you name it. And that is the essence of what a community is places where children and families congregate. And you would be hard-pressed to find a location that is a sufficient distance from those places, yet still offering and providing those things we just covered as being mitigators to risk. So all of that is weighed and taken into account before a move is either approved or submitted back to the hearings and release unit for further consideration. And so ultimately, this is the best available option at this time for Mr. Hinton to address and meet all those needs that we just talked about.
Obviously, we don't want sex offenders, let alone level 3 sex offenders living in our community. Is there any way, or have any other towns that you've ever heard of passed an ordinance banning them from living in their town?
Indeed, residency restrictions as they're more commonly known. And yes, there are residency restrictions in towns throughout the state. And ultimately, the ones that have fallen into legal challenge, where they've displaced a registrant based on there either being a level 3 or some specific detail of their offense, in those lawsuits, ultimately the cities have lost, as it's unconstitutional to eliminate someone from a community, to say that they cannot exist because of something they might do. And so ultimately, it's costly to the city. Now, for those communities that think, well, we've got a great city attorney, they're going to craft the world's most perfect ordinance, it leads to other considerations to have to weigh. One, what's the magical distance? Because there is no research or science that supports a distance. Every ordinance is unique, and the reason isn't because one school is more vulnerable than another. It's because the city sat down and drew circles around all of those places that people couldn't live near, and where those circles didn't intersect, they found that they had a neighborhood where they could live. Now, obviously, that's problematic if you live in that neighborhood. And so then the city is forced to either broaden the circles so that they all intersect, thereby eliminating the city from residency, or putting a park bench or a daycare or whatever the case may be to fill that void. Ultimately, though, the end all is that it leads to homelessness. It doesn't cease these individuals from existing. So what they'll do is then live on the fringes of your community. They'll re-enter for food and for shower or whatever resources they need. And they have to check in with your local law enforcement weekly, which is a huge drain on those resources that they have. and then the likelihood of them falling out of the compliance with the registry goes up. And so again, that it destabilizes and it's ineffective in mitigating risk. Often can lead communities to believe that they don't have to be worried about sex offenders. Communities with residences, often if you were to poll citizens there, say, oh, we don't have to worry about that here because sex offenders don't live here. But as you see from my earlier slide, that's not true. It may just simply mean those subject to broad public notification don't live here. Those other registrants very much do or may pass through. So again, that broad awareness is just so very, very critical.
Now, Brad, I always thought that once a sex offender was civilly committed, they would never get out. How is it that Larry Hinton got out?
Yep, so if somebody gets civilly committed as SPP or SDP, so sexually psychopathic personality or sexually dangerous person, they enter into MSOP, the Minnesota Sex Offender Program, through the Department of, or DHS, Department of Human Services. And ultimately, they will progress through whatever programs and protocols they have in place. And then ultimately will be granted provisional discharge by a judge, if they're granted provisional discharge. And so once provisionally discharged, then DHS, if they're a dual commit, in this case, is Mr. Hinton a dual commit?
I don't believe so.
Okay, I don't think so either. So he must not have gone all the way through full civil commitment then. But in the cases where they do, there would be a dual commit. And so they would work both in concert with corrections and DHS reintegration specialists to ensure, again, compliance with those release conditions and so on. So Mr. Hinton is not a dual commit. So he was not full civilly committed. He was considered for it, but ultimately did not go into civil commitment. But that is an important point to make, is that he could still. The county of commit, or in this case, counties of commit, either, could determine at any point that they want to petition for civil commitment and take him up before a civil commitment or civil judge and make their case for commitment. So to answer your question, Chief, and it's a good question because it comes up a lot, for those who do get that civil commitment component, they go into MSOP, and then to come out, they have to petition the judge. The judge will then determine provisional release, and ultimately, if they're able to, they may petition for a full discharge down the road.
There are children who live in that neighborhood that he moved into. Is he allowed to be around or to live around children?
I'll take that one. So Mr. Hinton has a very strict condition that prohibits him from any direct or indirect contact with minors. He is very well aware of any sort of boundary or parameter that he can and can't have with a minor. Can he have any contact at all? No. There's also a difference between incidental contact. So we give an example. We always give an example. Let's say Mr. Hinton were go to the grocery store, and he is going to check out, and there's a male or female on one side that looks, he or she may or may not be an adult, not sure. And then there is obviously an older male or female, someone checking him out. He must go to the older person. He must not by any means try to gain any sort of contact or dialogue with the person that may be a minor. As far as individuals or minors, say, walking down the street, there is nothing that prohibits Mr. Hinton from being on the street, but he knows he has boundaries or directive to either walk the other way or across the street so that he does not have that interaction with minors. Do you have anything else on that?
Yeah, I think it's dynamic, as Gary explained too. And so there may at some point be a scenario where maybe a family member or a loved one has requested special permission for him to have contact with their minor specifically. All of that must be approved through supervision and treatment. It'll be a combo to do that. So if you see Mr. Hinton engaging in contact that appears to be incidental or even direct, and you don't know for sure, I want you to call. If you think that contact looks imminently dangerous or harmful, call 911. If it's just questionable, you're not really sure about it, but you want more information, contact the phone number for the agents and let them know what you saw, where you saw it, and they will definitely get back to you. They may not be able to divulge all of the specific details, but that information coming in is just so critical. And that is why notifications like this are so important, because we need everyone working together, everyone's eyes and ears.
So he wouldn't be allowed to have access or contact with children or minor children who are within his own family either then, correct?
Unless
Yes,
specific.
that is
Unless
correct,
it's
unless he
specifically-
would specifically ask us and we would have what we feel that the tools or dynamics in place to approve that.
Is Larry Hinton allowed to go into bars or liquor stores?
That is a definite no. Mr. Hinton does have specific conditions that does not allow him to use or possess alcohol or controlled substances. There is no reason for him to be in a bar or a liquor store.
What about if he's at a public park or the public swimming pool or the fitness center or a public library?
Those places will also be not allowed for him. Obviously, a public park or a public place as that could be more minor driven or more populated with a minor population. So we definitely want to keep him away from those areas, and he's aware of that.
Can he have access to the internet with, social media or a smartphone or, anything like that?
So he does have, Mr. Hinton does have the privilege to access a smartphone, but he must make agents aware of that. And then in return, agents place a monitoring software on that phone to be able to basically see every keystroke that he makes on his phone. Social media, no, that is a directive, no social media. He should not be on any sort of social media. But in regards to a specific smartphone, yes, with parameters around that, as I stated, with the phone monitoring.
Does he have a curfew or is he just allowed to come and go as he pleases?
He does have a curfew in place, but that curfew goes along with what we call our phases. Now, he also is going to have what I talked about earlier is a pre-approved schedule. So just because someone might see
Thank you for taking time to watch this video. The information that we shared here today is important. Obviously, if you've made it to the end of the video, you know that. So please share it with your friends, family, neighbors, acquaintances, co-workers, so everybody is aware of this information. We at the Blue Earth Police Department feel that a well-informed community is a safe community. Thank you.